Morning once again. We are going to continue in the series of topics under the application of legal materials. So far, by way of recap, again, we've treated legal research, why and how legal research is done, the concept of library, and the other uh, things to be known under that. We've looked at statutes, law reports, that is case reporting. And in the last class, we looked at periodicals or journals. And this morning, we are going to look at the reference book, and then we can take on the other remaining topics for this section of the scheme of work. So our focus today is reference books. I want to believe you can hear me clearly, so I'll know that I'm not speaking
Yes,
to
sir.
you. All right. So we're looking at reference books, and the first question that we need to ask is, what are reference books? That is a question that we need to ask, and as much as possible, we also need to provide an answer in order for us to be able to drive home our point. So, therefore, by way of definition, reference books are authoritative texts that provide foundational knowledge, definitions, summaries, or key factors or facts about the law. The development of legal education or our legal system is dependent on many things apart from the laws made, but legal materials written or published by renowned scholars in all areas of field or field form what also what makes up our legal system and the development of law in our society. And in the field of law as of today, we have several legal scholars who have earned their own name by virtue of the contributions they've made to legal education. And these scholars and their published books becomes reference points in dealing with issues of law, because it is believed that those texts or books are products of a well thought out idea. And that's why, for example, when you're talking about experts in the field of land law in Nigeria, for example, we will refer to the likes of I.O. Smith, refer to, I think Emeka Chiano is also one of the leading scholars in that aspect. And these scholars have engaged on this subject for over 3 decades. So their wealth of knowledge becomes very useful, authoritative as well on matters that are called to question. So reference books, like we have rightly stated, are authoritative texts. And reference books are not read from cover to cover, but they are consulted on or for some specific information. So, meaning that yes, you need a definition to be given. If you take on the Black's Law Dictionary, you cannot read Black's Law Dictionary from page 1 to the end. It will become boring or unsatisfying because of the kind of book it is that it is. So, when you need to have a concise definition or a working definition, the place of call is the reference books. And apart from definition, there are other key knowledge that can be derived from reference books. In it, like we rightly said, you can look up some facts, even rules that govern some aspects of our existence. And at the same time, some of these authoritative texts provide um, summaries of legal doctrines that have been entrenched in the field of law, and then they provide the form of summary, some form of analysis, and so on and so forth. So reference books are consulted for specific facts, information, definition, summaries, and so on and so forth. So having gotten the understanding of what the um, reference book is all about, we want to look at the categories of reference books that we have. And if you look at the screen, you see about 6 of these categories provided here. Of course, these are not all in number, so as not to have the video that we are giving you all that goes under reference books as source of material. So therefore, we are going to deal with these 6 in the course of these studies. But you can as well do some other research on the subject. I'm sure you will still find some examples. But these 6 that we have listed, let's hold the point for our lecture, and it will be sufficient for us for the purpose of teaching and understanding our reference material. So therefore, I'm going to take them one after the other with the sole aim of understanding what they offer, the category of reference material, and the areas of information that they cover. So starting with the first one, legal dictionaries. Legal dictionary performs the function of defining legal terms and concepts. I'm sure that when you take a normal dictionary and We want to look up the meaning of ownership. The ordinary dictionary as a reference material can provide a definition of ownership in general perspectives. But when it comes to legal dictionary will go beyond mere definition that is common and include what ownership connotes in law, and sometimes give you other information on that. So there are different terminologies that the normal dictionary as a reference book will not be able to do justice to. But legal dictionaries provide more as is required for the purposes of legal education or research work. So, what are the examples that we have under legal dictionaries? We have the Black's Law Dictionary, which is in a different edition. I think we have up to the 8th edition. If we deny it, it's not available yet. And aside the Black's Law Dictionary, we have the Osborne Concise Law Dictionary. We also have Ghana's Dictionary of Legal Usage, and so on and so forth. There are quite a number, depending on the jurisdiction within which you are searching for them. But the key point on the legal dictionaries is the fact that it helps to define legal terms and concepts. It provides deeper information on subjects, on terms and concepts, especially as it relates to legal studies or legal education. So that is one example of reference books, the legal dictionaries. Number two, we have legal encyclopedias. Legal encyclopedias provide comprehensive summaries of the law arranged in alphabetical order. Comprehensive summaries, meaning that it moves from the surface summary to the one that is deeper than the normal. And we have, for example, the Horsebreed Laws of England, and then some others. I think we also have these two, but at the same time, other clients may also have the their own type of legal encyclopedia. But whichever one that you come across, what we want to establish by virtue of this class is to submit that legal encyclopedias are reference materials that provide comprehensive summaries of the law, especially arranged in alphabetical order. This may appear to be similar to the definition we have provided for legal dictionaries, but at the same time, while the legal dictionary will provide definitions, a legal encyclopedia will take it further to provide summaries. Legal dictionary do not generally provide summaries as legal encyclopedias will do. The third is textbooks and treatises. textbooks, and treatises. Of course, it can also mean, we can also call those procedure manuals. Okay, procedure manuals. That's number three, textbooks and treatises. And what are textbooks? This should not be new to anyone. They are detailed explanation of specific branches of law or subjects authored by experts. I once gave examples of legal scholars that we have in Nigeria, and uh, with pride, we have some of them in our faculty. We have the likes of I.O. Smith, who, with his several publications on real property in Nigeria. And one of the examples of his legally scholarly work is the practical approach to law of real property in Nigeria. The emphasis or the focus of that text is on real property in Nigeria. As a matter of fact, as I just admitted student at the year 2004, I had to travel all the way from Delta State to Lagos State to purchase I.O. Smith's book on land law because of my desire to have deeper knowledge in the course. And of course, I wasn't disappointed if at about maybe 18 years back, that book or his work has become soft after work, then you can imagine the kind of scholar that he is. So that's about 21 years ago. Now, these are experts who have prepared precept upon precept, step upon steps, and dealt with issues of laws. And by virtue of their knowledge and practice, their legal work has become a form of reference books. As a matter of fact, in some judicial decisions, judgments, the justices of Supreme Court or Court of Appeal and High Court judges make reference to this scholarly work. We have example of Aguda, practice and procedure in civil actions in the High Court of Nigeria. And another renowned author, Fidelis Nwadialu, the author of Civil Procedure in Nigeria. That was one of the books I also bought as at that time. These are group of scholars whose work or knowledge transferred into text have become books that can aid legal research or help in determining legal issues, especially in the area of their expertise. So when you talk about civil procedure in Nigeria, the likes of learned author like Fidelis Nwadialu, come into play. So many a times, of course, even when we prepare our lecture notes, we do research and all. These are the authors and even the ones who are coming after them that we consult. And by virtue of their knowledge, we can rely on the position they hold on a particular subject as authoritative indeed. So that is textbooks and treatises as one of the categories of reference books. The fourth we have here is law reports indexes. And of course, we've talked extensively on case reporting or law reports, the usefulness to legal studies or judicial practice, and so on and so forth. So the indexes as reference books helps us to locate in various law books. Okay, like for instance, we have the Nigerian Weekly Law Reports Index. It contains details of the weekly law reports, the year, and different subjects that they address. So that is an example of law reports index. The index is our focus as a reference book. Charlie Obom, you have a question?
Yes, I have a question, sir.
Charlie,
Can you hear me? I have a question, sir.
yeah, you need to speak up a little.
Okay. Sir, when you were explaining textbooks and treaties, I did not really get the explanation of treaties, but I got the explanation of textbooks. So I want to know if treaty is the same thing as textbooks in this context, because my knowledge of
I'm unable to
only
hear
one.
you, and I believe others are also not able. So please, you can make
Sir,
use, like your network is not very strong, so you can make use of the question and answer platform to send your question, and we will make effort to provide answers to you. Okay?
okay, sir. Sir, you said, sir, can you hear me?
Yes, please.
He said when you were explaining textbooks and treaties, you only explained
As Aliyah,
textbooks. You didn't. Yes, sir. He said when you
okay?
were explaining textbooks and treaties, you only explained textbooks. You did not explain treaties. That's what he was saying, sir.
Okay. All right. Some, it's also treaties are also a form of reference material, and more like written works that deals with some specific subjects. Okay, for example, you can have maybe treatises on political theories, or um, maybe a particular book that deals with, you know, either vocabularies, either maybe some form of theories and all of that. So that's basically what we mean by treatise. They are also like a collection of books, just like the textbooks, that provide access to different work that has been done. Okay, you can do more research on that, as just to have uh, a better understanding of what we are talking about. Okay, so we move on from that. We've looked at law reports, indexes. Like I said, the law reports are not in themselves reference books, but the indexes are what we are focusing on here, because they provide access to the available law reports for legal research and so on and so forth. And the other one is bibliographical directories. Okay, this is another type of reference books, and these contain information on legal personalities, judges, and lawyers. And of course, you can find examples on bibliographical directories like who is who in Nigerian legal profession. That particular directory will list eminent personalities, justices of Supreme Court, of course, very renowned jurists who have contributed, uh, you know, very seriously to our jurisprudence. So we have such as also a form of reference books. If you want to look at the list of lawyers in Nigeria, the list of SANs in Nigeria, the list of those who have occupied the position of the Chief Justice of Nigeria, or all the justices who, or those who have ever served at the Supreme Court at one time or the other. This kind of bibliographical directories contain all of those information. So it falls under example, of reference books that we are considering this morning. And the last but not the least on the schedule is government publications. What are government publications? These are reports made or generated by government. Sometimes when there are maybe general meetings, or maybe, for example, there was a time we had a confab, we have national gatherings that requires that at the end of such submissions, their papers are released to contain the content or the outcome of such exercises. Like you must have heard of white paper, okay, or report commission and other similar publications come to play when we're talking about government publication. We also have National Assembly report based on the activities of the National Assembly in recent times, maybe on a particular subject or maybe on a particular legislative procedure. So all of these are examples of government publication. Okay, so with these six, I believe we have the idea as to what reference books are and the categories that we have, which we have discussed, in the course of this lecture. Now let's move on this topic to look at the importance of reference books, or maybe I should allow the class, to those who have not spied my slide yet, to tell us the importance of reference books, or they are not even important in the scheme of things, and we shouldn't have been wasting our time on them. So class, what are the importance of reference books to legal education or legal research, and so on and so forth? Any answer?
Yes, sir.
Yes.
Okay. One of the importance of reference books is that it makes research work easier.
Okay, that's number one.
It acts as a guide towards legal research or legal writing that one wants to engage in.
I didn't get that.
I said that it acts as a guide towards legal research or a legal
Okay.
writing that one wants to engage in.
All right, thank you. That's correct. Yes.
It allows individuals to be sure of the points that they are bringing forward.
Okay. Yes.
It provides foundational knowledge or specific information about the law.
Okay, that's beautiful. Yes.
It gives a quick reference to a matter of discourse at any particular point in time.
Excellent. Yes.
It helps
It
to
helps us.
So I also believe that it gives us an insight into the history of Nigeria's legal system.
Can be used like what?
It also gives us an insight into the history of Nigeria's legal system.
Okay, all right, that's okay. Yes.
It helps to trace the history of laws.
Okay. Any
It
more?
helps us to understand the rationale behind the laws.
Okay. All right. Thank you very much. Those are various things that we can consider as the purpose or the importance of reference book. Now, let's look at what we have before us. Number one is that it provides authoritative definitions. And I was stated that earlier, wherein we did say that legal dictionary provides, definitions that, of course, other reference materials like normal dictionary will not provide. Then it offers quick access to legal principles. When we were dealing with a legal encyclopedia as a type of legal or categories of reference books, we did say that such reference book provides comprehensive summaries. So, and that's why under this importance, we say that it offers, quick access to legal principles. Then it also helps trace the history of law. Someone said that in the course of our question time. Then it serves as a starting point for deeper research, because sometimes when you consult some of these reference books, the kind of insight that they provide help you to have a good view of what kind of research you are embarking on and the expected outcome. Because if your knowledge about the subject is shallow or before consulting all of those things, in having to consult those reference books, you become aware of uh, other things that relate to the purpose of your research. That can even broaden your knowledge. That can even pull you more to do further research to have a more robust paper at the end of the day. So reference book serves as starting point for deeper research. It guides you in understanding complex legal issues. And at the same time, we need to add that it provides citations. For example, we talked about law report indexes. All of those help to provide citation, which will give you easy access to the location of a particular legal authority that you need. Okay, so those are the field that we can itemize in this class. Then the next question is when to use reference books and the advantages that are attached to it. Now, when to use reference books include when you need a clear definition of a legal term. Now, in any legal discourse, as you must have noticed in the course of our various lectures, if a particular subject is mentioned, one of the very first points of call is to provide a working definition for that subject. And it means that it may be difficult to achieve a proper lecture or have a good understanding of a particular subject when you do not have a definition that can provide the needed guide on the subject. So reference books help to to provide that, just like we've mentioned under the categories. And of course, when you need the definition of terms, to them. Then another advantage or when you use reference book is also when you want to understand the overview of the legal field. This on its own is also another important time. Sometimes the reference books provide history to some legal aspects, I mean, some subjects. And then when you really need the history, you need to have a general overview or summary. You can refer to a reference book. Then when starting a legal research project, you also need reference books and to help you in locating your point easily, and then you can be developed in line with the submissions that you intend to make in your legal research. Another time to use reference book includes when looking for citation to cases or access or statutes. I mean, like we did say, the law report indexes provide such services to any researcher at all. Then, therefore, we now ask ourselves, what are the advantages that are attached to reference or the deployment of reference material? Number one is that it it provides you with reliable and authoritative definition on some concepts. Okay, and of course there are definitions that you will get within the normal reference books which are not pertaining to legal, that may provide meanings that are less than the actual meaning in law. And the good thing about using legal reference books is that it will provide you with authority, a very reliable and authoritative point or definition. Then it's easy to consult for quick answers. And then it's also useful for beginners and experts alike. Like if you need to brief a case now, you may not really have an idea of where and where it will be, but when you consult the index, there are indexes that deals with topic, there are indexes that deals with page, and so on and so forth. Then, what are the limitations of the deployment of reference book? Limitation or the challenges that are, is attached to all of this. Number one is that it may not complete latest case law. Being reference books, they are not easily reviewed. We have various textbooks that go from one edition to the other. We have edition one, edition two, but unlike the Black's Law Dictionary, Black's Law Dictionary has series of editions, but one thing is that if, for example, you are looking for recent cases, you may not be able to find them there except when they are being updated. Then, again, they said that often general in nature, that is not always detailed on specific point. Some reference books may have this, while some may be able to provide the detailed information that is needed. While again, another limitation is that some are expensive and may not be readily available. That is a fact, and some will become outdated quickly due to the way the society is changing and the way the law is also changing. Again, uh, some are costly and not readily available in digital form, meaning that you have to do all your form of searches manually. Unlike if there are, those types that can easily or that are already digitalized that can easily be, consulted or accessed without having to do rigorous aspect of of research. And then not all areas of Nigerian law are comprehensively covered. That's one thing that is also a limitation to the usage of reference books. So, with this, uh, we have the basic knowledge and lecture on the topic um, reference books. Now, I have some kind of questions which I want us to provide answer to as a way of wanting to understand what we have dealt with so far. So I have some uh, class exercise here, and which borders on the topic that we have dealt with on periodicals and reference books. So the first question is, why must a lawyer read both law reports and journals? And then, can articles in journal be cited in court? When is it appropriate? Then how do you explain the differences between Osprey law and ordinary textbooks? And we have answers from the platform. Hello? And then you can begin to send in your attendance into the chat. I'll open the chat up now. You can send in your attendance there while we take the questions or the answers to the questions. Yes. Anyone? Why must a lawyer read both law reports and journals? Can articles in journals be cited in court? When is it appropriate? Then how will you explain the difference between Osprey laws and or ordinary textbooks as a form of reference books? Yes,
Good
Babalola,
afternoon, sir.
please go ahead.
Hey, Babalola.
Babalola, yes.
Yeah, it is expedient for lawyers to read law reports and journals, because when you read law reports, where you have judgments that are current, that have just been decided upon, the law reports can avail you that. And if there are new discoveries in law, journals can actually avail you that knowledge as well. So that is why it's important for a lawyer to actually read both law reports and then the journals as well.
All right. Thank you very much. That's beautiful. Yes. Yes. Ayolaja.
Good afternoon, sir.
Good morning. Yeah.
Can articles in journals be cited in court? So I think articles in journals cannot be cited in court as they are only binding on us to make research. So we can only cite the primary sources, which are the likes of the Constitution, acts, or statutes in court. Articles in journals are not binding in court, so they cannot be cited in court, sir.
So
Okay. Thank you for your contribution. Yes.
can I differ on that, sir?
Please go ahead.
Actually use what we discover in journals and in report as a persuasive, instrument for the judge to actually consider the subject matter that is in court, can actually be stated in court. It might not be an authority, but it can be used as a persuasive weapon as a lawyer.
That's a beautiful one. Yes, I agree with both of you. The clarification just given, correct the limitation of the first answer. So it's not that when you cite it, for example, you cite a journal written by a renowned scholar on a particular subject. It's either that it points the court to such an article, and even the reference books on such subject. But like the person who spoke first said, it does not constitute an authoritative part of the whole process, but it provides a kind of a persuasive effect to the work before the court. Yes. Yes. Okay, so is that all that we can do? All right, so that's okay. I agree with the yes, I agree with the submission on why lawyer must read both law and report. The truth remains that it serves as a way of enriching our knowledge, because nobody knows it all, and then when you come across submissions in both law report and journals, it enriches your knowledge. And I also agree with the fact that journals can be cited, but of course, it's just an addendum or an addition to whatever submission a party is making. But it doesn't take the place of judicial authorities that have been, that has emanated from the courts. And I think with that, we bring the lecture to a close for today. And then when we reconvene, we'll look at the remaining section of this part that we are examining. So thank you very much for your time. And thank you very much for listening. We see some other time. Enjoy the rest of your day.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, sir. Goodbye.